Hi, guys, and welcome to our latest episode of CondoLand. I've got Dean McCabe, president and founder of Meritus Group, and I've got Chris Jaglowitz, owner of Common Ground Condo Law. And today we're going to talk about court-appointed administration. What is court-appointed administration? The good thing is for this podcast, I don't really know, so I'm going to be asking a lot of questions to the two experts I have in the room. They're going to tell us all about what it is and the fun stories that come along with it. So let's get started. First thing I have to ask is what is this? I've had some experience with it in the past. I've taken over buildings that have been under administration temporarily, but kind of administration light. You guys are into the more serious stuff here. So why don't we start by basic question? What is this?
Sure. Thanks, Eric. Really glad to be here on CondoLand. I guess what I would throw out there is court-appointed administration is when the authorities of the board of directors, the elected board of directors, have to be suspended for a time by the courts in order to allow for the operation of the community. Maybe it's legal issues they're facing, maybe it's financial issues they're facing. But there are times when a community has proven that sometimes it's proven that it can't operate itself, and sometimes it's really just borne out that a court-appointed administrator can very efficiently and maybe faster can help right the ship. And so those are things that the court looks at, and obviously they take it pretty seriously when they suspend the rights of the owners to democratically elect a board of directors.
So this is essentially when democracy has completely and utterly gone off the rails, and the court is stepping in and saying we need someone who can step in their place. Can we get this for like national governments? Is that a thing can we modify this in some way? No. Okay, that's great. So how does a community end up with an administrator? It's not going well. The ship is going way off course. How does this happen?
The short story is there, Eric. It's the administration aspect is all covered by Section 131 of the Condo Act, and so a party would go to court. And when we talk about which party would go to court, it could be the condo corporation, it could be any one or any or group of or all of the owners or the mortgagees or other stakeholders. So it's there for in some drastic, unusual, weird situations where some party would go to court, and what they'd have to convince a court is that it is just or convenient, having regard to the scheme and intent of the act and the best interest of the unit owners. So that's the threshold. So you can see that can cover a wide variety of situations, and that the test is pretty broad. And so preparing that evidence and putting it together and then convincing a judge that it's the right thing to do. And the judges, as you said there, it's like to suspend democracy it's a high threshold, and it's going to have to be a pretty extraordinary case and not just some routine little squabble that could be resolved by people talking or through the political means of removing directors or having elections. So it is a drastic remedy, like a nuclear option, let's say.
So this is going to be a very fun podcast, is what you're saying. So before we get into those cases, the nuclear option, are there any cases where this may come up where it's not a disaster, where things haven't gone horribly wrong? Has that happened?
Yeah, it's happened. I think that there are times when those requests are a little preemptive. I've had a couple of cases where shared facilities, where the parties just recognize the fact, whether it's two or three parties, we're going to spend tens of thousands of dollars on legal fees and mediation and arbitration unless we can get somebody in here to do this. And I think it's a pretty laudable step when a board of directors says we need somebody else to take this from us. We're so entrenched in our fights that maybe we're having difficulties as a group actually making, we can't seem to see past where we are, the trench that we're in right now, and we can't see past to the end. So I think it has happened. It's rare. I think, and you have to remember too, this happens when the courts see that things have gone very badly, and so in a lot of cases you have to prove to a judge that the bar has been set at such a level where this community can't operate itself. I've had one situation where I was appointed. It was where the management and all of the board members had resigned following a series of death threats and bomb threats and
Ooh.
and things like that. And there was nobody left to run the corporation. And so that was when the court stepped in and said, okay, we're going to right this ship. And
And no death threats after that. That's hopefully.
well, a couple, but
Probably a few more. So how does one? Who are these administrators? My next question. I know, Dean, you had mentioned earlier, and I forgot in my intro, but you're with Amicus Community Administration. So you've done this a few times, but how? I've seen other people in this role. Who are the people that get chosen by the courts? How does that process play out?
and Chris, I'm sure you'll know lots. I can tell you there are a couple that that are well-known names in CondoLand. You know, Armand Conant has done it on several occasions. Bill Thompson has done it on several occasions. There are others, and I'm not. One of the things is I don't have any stats, so I really don't know how many are out there right now. How many court-appointed administratorships are currently ongoing? So I don't know. That's something that might be very interesting. Did you have? What about you, Chris? Where would you? What do you think? How many are out there? And
Who are they? Who are these people?
Yeah, so historically, and of course, remember, because you have to go to court to get an administrator appointed. It doesn't just happen on its own. And of course, the court gives a decision. So the only way that we can tell how many administrators there have been appointed is to sort of find those various court decisions. I'm aware of maybe a couple of dozen or so. So, I mean, it's not a large number. And over time, and remember, this feature has only been available since the Condo Act 1998. So since it came into force in May 2001. So we've only had 25 years of where administrators could be appointed. It wasn't available under the previous Condo Act before 2000. So it's figuring a couple of dozen. And in the early days, my recollection was that those were typically lawyers who were appointed. So you can imagine that that was a pretty expensive proposition. And there are still cases where it makes good sense to have lawyers appointed. But there are many other cases where to say, well, the issues that this community are about governance or about doing contracts or doing repairs, you don't need a lawyer for that. Maybe it's better to have an engineer or a condo manager, and who in many cases will be the right fit for that kind of situation. Because remember, the administrator is typically exercising the powers of the condo board. And so having a condo manager involved in that is typically would make the most sense and be the most economical.
Right. Okay. So we've kind of covered what it is, who they are. So give me some examples, guys. I heard death threats and bomb threats. Maybe you can elaborate on that, or if you have any other stories. But give me some examples of how bad does it need to get, aside from those first few we talked about, where it's not a disaster. How bad does it need to get to this point where democracy is suspended, the court appoints someone, and it's now temporary dictatorship until we've righted the ship? And then follow-up question on that, as I think of these as I go. When does it end? Is this a fixed time frame, or is it based on certain metrics that are met?
Good.
why don't you take that one, Chris?
Yeah, those are good. You loaded a couple of questions in there, Eric. Let's start with sort of the threshold. What is the threshold at which the court will actually appoint an administrator? And again, as we talked about before, it's got to be sort of a pretty serious thing where like in the case of a shared facilities administrator being appointed, where like there are constant work orders, where things aren't getting done, where the dysfunction of the shared facilities committee was to the point where, and because of their agreement, it just had required unanimity or a certain threshold at the shared facilities committee. So nothing ever got done because you had some parties that say, yes, we want to do work and we need to get it done. Others saying, no, we don't. And so it would always be a stalemate and nothing would happen. And the city would come in and say, you guys aren't doing repairs. We're going to issue work orders. And there was danger to the residents for fire and life safety systems. So, I mean, that was a pretty clear case. But it took a while to get there because you you have to do a bit of a gut check and say, well, what is the extent? Like, this might be important to us, but will it be sufficient to convince a judge to say we have to do something here, and an administrator must be appointed to protect everyone and all the stakeholders? And it's a gray area, and it's hard to pin down, but it's got to be in the interests of the owners, and it's got to be serious.
And how about timeline? Like when does it end? What's the end look like? We've kind of discussed what the start of this thing looks like to a point. Is it based on things are now good and the judge is convinced, or is it a fixed time frame, or how do they do that?
Well, let me just jump in. I want to add one thing over sort of the life cycle there. And there's a couple of things that I think people can look at. If you've got a shared facilities and you haven't been able to pass a new budget for over 2 or 3 or 4 years because both sides are so entrenched, that's a tip. Like, you're looking at a red flag there. Right, you can't even pass a budget, and so those types of things. That's when it starts. That's kind of the precursor, right? You're looking at that. We're getting nowhere. We're not making decisions at all. We're spending more time fighting, and so that can be the precursor. And then when it ends up, I mean, in a lot of cases, there are requirements on the court-appointed administrator to report back to court, not only to court but also to the owners. So whether that report to the court is due on a quarterly or a semi-annual or annual or even an annual basis, you'll submit that, and in each of those reports you will say, do I as the administrator still feel that this property needs an administrator? Okay, and those are things that the court will look at in reviewing the work that you've done. They'll authorize, they'll endorse all of the work that's been done, and then that report is sent out not only to the courts but also to all of the individual unit owners, and they can agree with it, or they can request, no, we'd like a hearing. Maybe they feel it's time and we're ready to take this, the operation of this community back, and so we'll go. So it really does, I think in a lot of cases, the process you go through to have a court-appointed administrator appointed is really the same process that you go through to have one unappointed. Or
now, could a resident or a former board member, and which is, I assume, who it would be, can they apply to the court to remove the administrator, or does that have to come from the administrator? That's a Chris question.
Yeah, it is possible for any one of those stakeholders, including the parties who came to court, to have the administrator appointed, to either change the administrator, which has happened, or to remove the administrator, saying the situation is good enough now, we can go back on our own. And of course, it's open for the administrator to come back and say, I'm done here, I'm ready to be discharged.
Right. And I guess it depends on the individual. If it's the individuals who caused the problem in the first place applying to get the administrator gone, the judge might see it differently than new people in the community who want to step up and govern themselves.
And of course, sorry, Dean, and of course you will have scenarios where you have one stakeholder group might say, we're ready for the administrator to be removed, and the others says, oh no, we're not. Yeah. So then a judge has to decide whether to keep the status quo or to make a change or to discharge the administrator. Dean,
I think the thing I'd add to that is that really in the same way that you have to get the court's endorsement to have the administrator appointed, you need that court, that officer of the court, that judge, to say, yeah, you know what? Now you've got to prove to me that we're ready to remove it, right? Because I'm going to sign this piece of paper saying that this place is good to go back and take care of itself. I need to make sure that it is. What is your plan? Who's going to be on the board? Do you, and make sure that we're not going to be back here again in 6 months.
And that's another follow-up question is how often, maybe you guys don't have the stats on this, but how often do these communities sort of go back to their old ways and have a repeat administrator where it's, they got rid of the person, they went back to self-management or self-governance, and then it fell apart again. Do you see that?
I'm trying to remember a specific instance of that. I suspect it will have happened because there have been some condos that had been under administration for a long time and would inevitably slip back into their old ways. So I would say probably. I don't know for sure, but that's my guess.
Yeah, I would think so too. I think especially where the problems, look, you can have financial issues in a community and the administrator can go in and solve them. You can have governance issues in a community and you can, pass bylaws and address those and have new steps put in place to protect, the future, and the administrator can help clear those up. You can have operational issues or reserve fund issues, maybe major expenses and projects that need to be done that the community is having a difficult time doing on its own. And when those are finished, but when the issue is sort of community entrenchment and community disagreement, uh,
Yeah.
those they don't really go away, right? Even when the administrator's gone, I have seen in one case where the administrator left, and like everything went quiet while the administrator was there.
Right.
Everything went down. It went quiet because there was no authority to be gained, right?
And
Everybody,
then you take the can off of
and then as soon as
the lid off of the can of worms and
yeah, once the administrator's gone, what's happened is there's power up for grabs again,
yeah.
right? And that's when the motivations come to roost.
So
So
it's basically rehab for a condo when it's a broken, like I understand when it's a project or bylaws and all that, fine. Um, but if it's a community issue, it's like rehab. You're gonna be fine during rehab at the resort, and then you're gonna leave and 50-50, you might go back to your old ways just because you're exactly right. You got a power vacuum now. And
It
if you had factions in the building that didn't like each other, they're not going to start liking each other, you know, because of the quiet time that they had under you, right? And so let's just dive in. Let's get into some stories. Like you guys have had experience. You can't name names, of course, or addresses or anything, but I asked it before. I'll ask it again. How bad does it need to get specifically for this to come up? Like we've every manager listening to this podcast has had probably some experience with a rough building or a bad board or a nasty community that doesn't like each other. And we get requisition meetings, we get the letters posted on the doors. We've all seen that kind of thing. This is kind of the next level of that. So what kind of stuff were you guys seeing prior to, or was happening prior to you being involved in this?
One thing I'll add, and it ties to the last point there, is like, what are those natural factions that always exist that will lead the place back into administration potentially? And that is the resident owners versus the investor owners. That
Mm,
dichotomy, and that's a natural the distinction or a natural conflict there, because of course investor owners might say we want the fees as low as possible, and the
yeah.
others say, well, we'd like to live here and not fall into a pothole every time we walk down the driveway. So there's that, and that is typically some of the older condominiums that had fallen into administration back in the early days, like in the early 2000s. I mean, that would be, some of the scenarios that you'd see where they have no reserve fund. The city is coming in and issuing massive $1 million work orders to fix and to repair garages that are about to collapse. Like that is the kind of, like, historically, those were the early administrations. That's what brought them about.
yeah, the other thing when you see, I mean, we talked a little bit before about where you have different language, or when you see certain red flags, you haven't approved a budget in a couple of years, you can't get work done, there's, if you got boards working unilaterally because they think this is the best thing and the committee won't agree to it. I think one of the most dangerous words in shared facilities agreements that we come across is the word unanimity. I mean, if you've got multiple parties, there's a shared facilities entity out there with 14 shared partners, and they
That's just mean.
approved unanimously. That is, you are setting yourself up for complete failure.
I've got one with three condos and a retirement home sharing a roadway, and it's like just getting the parties in the same room is next. It takes a year to do that. But this is like shared facilities, you said, was kind of a new use of this tool. Most of this is happening in standard condominiums. Is that correct?
Yeah, the Condo Act doesn't specifically contemplate administrators for shared facilities. We did one a few years ago, and where we took the other side, the other parties to court, and ultimately they agreed to it. So the court didn't have to decide whether it was possible. So there is a framework out there. It's not a really good example, but that led us to the conclusion to say, why don't we build this into our agreements? Or when we amend shared facilities agreements, to have it in there as a potential option for when things get terrible. So
Right.
it is an option. The other thing is the parties, as you said, could agree to it. So it is there, and if the parties agree to it, the court's probably going to order it if it seems to make sense.
Yeah. Now you mentioned obviously like investors versus non-investors, and that's a conflict that makes sense. You're going to have a natural conflict there. Again, most of the managers listing this have also seen conflicts where that is not the case. We just sometimes personalities play a role here, and I guess that's a Dean question. Like, are you seeing most of this where it's a structural issue like a shared facility or investors versus not? Or are we seeing a lot of these just with personalities, just individuals, who want to govern differently than other individuals?
I think that what I have seen the most is more personality based than investor against unit
I
against.
suspected as much.
Yeah, or that's what I've seen certainly more. And you know what? There are people that just want to sow chaos, right? I mean,
Yeah.
you asked for a couple of stories. I had Chris will remember this. We had a situation where I was an administrator in a property, and an individual who I guess had previously been on the board and had access to records of the corporation, including the emails of all of the unit owners, hundreds of unit owners, and sent out a lengthy email one night, which I got a copy of from an anonymous email address, and where I was accused of murder, arson, running a court-sanctioned prostitution ring in the condominium. I'm not sure how.
But the court sanctioned it though, right?
Yeah. Well, there's, that there was as well as like the accusations were just so next level, and ultimately we did find out who that person was and actually threatened, a libel suit, and were successful in having that individual write a retraction and an apology. But it's that kind of thing. That's not. It doesn't matter if you're an investor or if you're an owner.
No, that's just
so chaos, right?
Yeah.
So,
yeah, and as you know, in these communities, like the more that happens, the more people wake up and become active and ask questions, and you can get buried in the aftermath of something like that as the manager, or in your case, I guess, as the administrator. It really can damage a community horribly. So how do you recover from that? How do you manage that? You've got that person, you went and threatened a suit against them, they retracted it, but like, that person's not going away unless they move out, right?
Well, and to be honest with you, that's exactly what happened.
Okay.
I mean, so what ended up happening there, and we initiated a libel suit. We came to an agreement. I mean, here's somebody where someone had very clearly and maliciously gone after my professional reputation, right? And there was going to be very real damages that could have resulted from that. And so we initiated a libel suit. We avoided that by coming to an agreement, but that agreement included paying legal fees and the fees associated, and those were substantial. They were, in excess of $10,000-$15,000.
Yeah.
And as well as writing a retraction and taking responsibility. And in the end, that's exactly what happened. The individual moved out, and so maybe there are times where it's just they move on from that situation, but it's not neat. I mean, poor Chris had to listen to my diatribes on many lengthy phone calls where I was so frustrated and angry at the fact that had gone on. But and it, to be quite honest with you, it probably extended that administration by 6 months, maybe more.
Right, just one individual.
Yeah.
And I'm pretty sure he moved into one of my buildings. No, I'm just kidding. But he moved somewhere, and unless he got a house, someone's dealing with him, right?
He called and asked me for a list of your properties there, right?
Yeah. It's where they all go. That's how it happens, eh? Yeah. But these guys go somewhere, and these personalities, again, you can't fix personalities. You can charge them lots of money. You can do that, but let's assume this guy didn't move out. I'm sure you have cases where the factions or the individuals stay put. Do you see an improvement? We kind of touched on this before, but does this help? Like, it helps temporarily while you're there, but does this help long term when the issue is when it's personality?
In some cases, like a party or even a board of directors might say, we're having if we're a really small condominium and we got to enforce rules, whether it's the pet rules or the parking rules or anything else, and the board says we're having a really difficult time, like objectively enforcing against our neighbors, and we're reluctant to instruct management to do that. Like that actually in some cases is a reason for boards to say, let's get an administrator appointed. So it's a new sheriff coming into town who's objective and doesn't have to live and see these people in the elevator or on the grounds, and to to do the dirty work there and to get the rules enforced and to get things put back together again. And it's a great deal easier for an administrator, whether that person is a lawyer or a condo manager, to be able to exercise, their knowledge and their experience and skills and their judgment in saying, what steps do we need to take in this community to get people respecting the rules once again and behaving well and playing nicely in the sandbox. So the administration aspect actually is a really good option in those kinds of cases.
Yeah, I assume what you're really doing is you're paying a bit of extra beyond the management company who you get to tell to do the rules or not. Because again, if you're enforcing unpopular rules, someone can just go to the board and say, well, tell your management not to. This takes that decision out of their hands then.
Yeah. And, Eric, another thing is that it is possible. Like, I mean, an administrator doesn't have to be an all or nothing proposition. Like a board can say, we're going to continue making the budget decisions and these sorts of things. And we can just have the administrator come in and be ordered to handle the enforcement or rule enforcement or whatever tasks we ask the court to order. So, I mean, any administration could be tailored to the particular needs of any given community.
So it isn't an all or nothing. You can basically say the board is responsible for ABC, the administrator is for DEF, and you would put that in your application to the courts for that administrator.
Right, and that'd be
I guess
set out in the
if you
court
have a
order.
mature group of people doing this as a tactic or a strategy, that could happen. If it's infighting and factions and personalities, it's probably less likely that that's going to be the case. Although I guess, and you could correct me if I'm wrong, the judge can still decide to do that, right? If a board is semi-functioning and there are problems, they can give the administrator responsibility over whatever the problems are, rather than a full dictatorship.
Or maybe it's major reserve fund expenses or projects or items like that, where the corporation is just having a difficult time coping with the fact that they've got to spend $1.3 million on a piping retrofit, and that's causing problems. Or the selection of the contractors. Both sides think the other side's contractor is not up to the task, or may not be above reproach, that kind of thing. So
administration light.
It is possible. Those are out there. So
right. So it's a little known tool that I think most people don't know about. Probably a terrible thing to tell lots of people about, because I imagine the number of applications from homeowners or old board members or whatever would skyrocket if this was better known. But it is, at the same time, it sounds like a very useful tool if applied maturely and responsibly, rather than as a bludgeon to get rid of your nasty board that you don't like, or vice versa.
I think things, and Chris would say too, you do have to recognize the fact that a judge needs to be convinced of the fact that this is necessary.
Right. So you've got that stopgap regardless. You've got a judge that needs to agree.
That exists. So.
Right. And of course, there's the cost of getting that. So this is not a cheap and easy process. It's not, something where you can just, pay your $25 to Condo Authority Tribunal. I mean, this is an expensive process, and to have to put together the evidence, and that's a tough thing to do. Like to say, we haven't had, a meeting in this length of time, or there've been no elections, or this is going on, or this place is falling apart. Like that, all that's got to be documented.
So as an owner, if you wanted to do this, you're really relying on quite a lot of records requests. You're probably getting your own lawyer to help you through this process, I would imagine, right? Because it's, one of the issues in the condo community is records and getting access to those. And you may have a board that says, hey, there's nothing wrong, and we're not telling you, we're not opening the lid on our dirty laundry here, unless you absolutely force us to. So yeah, this would be a challenge to do then. That's true.
Yeah, but I mean, the thing, the further point on the issue of the cost is it's typical that a successful applicant, whether it's a unit owner or mortgagee or an owner's group, if they succeed in getting an administrator appointed, they can ask, and a court will often give an award to say that party gets reimbursed its cost for bringing this matter here, because why should those parties who paid the cost be responsible for it when it benefits all unit owners together? So that part is there. So, but it is still a barrier, because those owners have to pony up the dough in order to get into court and to get.
There's always the risk risk that the judge may not agree.
Right.
As we know from our jobs, Dean and mine especially, some groups of people have different ideas, to put it nicely, on what's right and what's wrong. And so you may get a group of owners that really thinks the board is doing a terrible job and they need to go, but objectively they're not. They're doing
A
okay.
lot,
There's
a lot of Derek, people can only see their own facts, right?
well,
They
that's the problem, and that's why I think we should take this concept and apply it to higher levels of government. But never mind.
I,
Um,
I did want to, one thing I did want to ask you, we haven't touched on it at all, is just the fact that as managers, this doesn't need to be a scary prospect. Dealing with a community that has a court-appointed administrator doesn't need to be a scary prospect. You're now dealing with an individual who is knowledgeable, who, because the individual is making decisions, they can be quick, they can be nimble, they can be more cost efficient. Things can happen faster. So I think as a manager, I know there are times that maybe management companies look at this and they go, "Whoa, court-appointed administration," and that's a red flag for a property. But when you're working with the administrator, it really changes the dynamic of the relationship between manager and the board to manager and administrator. I think just because of that relationship. So something for management companies to consider as they look, if they may be asked to consider tendering on a project like that.
yeah, it'd be a drastic difference, because again, you're dealing with you're not dealing with a board of director at all. It's more dealing in the rental space where you've got an individual or a company who makes the decisions, a savvy business person, rather than what could be a great board or could be not as great a board. We don't, it's a crapshoot. I had a question and I lost it, so I'm going to let Chris talk while I think of that.
Good.
No. Just I'm just kidding. We're getting to time now. While we wrap up, I just wanted to know. So you had some fun stories. Well, not so fun, with some letters put out. You have any other stories that you want to share with the condo community? Anything that's not too heavy or too upsetting, but that kind of illustrates the point of what this is and when it's needed.
Yeah, I mean, I would throw. I'll just throw one out there, and Chris, I'm sure you may have one or two. But one of the things that I've got a property where I'm recently taken on the appointment as court-appointed administrator, and the property management company came to us. This was a lengthy fight. It was actually the subject of one of the ACMO luncheons. It was a file that was discussed at one of the ACMO legal updates, and so this is one where the management company submitted invoices for their involvement in the legal process for the appointment of the administrator, and it had been lengthy. It had been over a year that this dispute had been going on, and the management company's additional invoices for this totaled $57,000, and that accounted for over 400 hours. And as I reviewed these invoices, I called the lawyer. And I was going over this, it was really quite a surprising amount. And he said, "I don't know how they spent 400 hours on it. I only spent 180 hours. So I don't know how they could possibly have spent 400 hours. And I think, these are things that when you do step into an administration role, you do need to take a look at the recent past and just kind of make sure that people haven't been trying to take advantage of that situation."
Well, if you guys are okay going a couple minutes longer, it's a good segue into another question. Is what happens? You come in as the administrator, you've sort of taken the place of the board, and you do find evidence of fraud, or like criminal mismanagement, let's call it. What do you do in that case?
So basically, the administrator is simply has the powers of the board. So whatever the condo corporation could do, the administrator can direct the corporation to do against former, whether it's contractors, former directors, former managers, neighbors, anybody else. I mean, so those remedies are all there. It's just who is enforcing them. And just a further thing on the list of reasons that Dean suggested the administrator can be helpful is that here you've got a single individual or firm who's exercising the powers of the board in an objective, non-emotional kind of way, but in the best interests of the community. So when looking at it, that administrator can come in and say, "Yep, it appears that this party defrauded the condo corporation," but let me evaluate the evidence. Let me see what's there. Let me look at what the amounts are at issue and what objective sort of evidence-based decision can I make having regard to the legal fees, the prospect of recovery? Does it make sense? Is it going to heal the community or just plunge us further into chaos? And the administrator can make that decision. So
yeah, I'll give you a
yeah.
perfect example of that, Eric, and that was in a file where I stepped in as the administrator, and we had a what clearly felt like it could be some type of fraud. Okay, there was one company, a plumbing company, that had charged over the course of the past 2 years, had charged over $150,000 in fee. And when you looked at some of the invoices and some of the work orders, 2 guys on a Sunday for 7 hours for a kitchen sink backup. I mean, that's a $4,000 invoice, and that's not accurate, right?
It was a gold pipe, though.
And what's that, sorry?
It was a gold pipe, though.
I mean, I'm sure that it was a really, really bad clog, but regardless, look at that and you think, okay, something doesn't flush. But at the end of the day, and so put yourself in the position of a board who now wants their pound of flesh. They want to get that back. They're going to make somebody pay. They're angry about that. I had to look at that and go, I'm going to spend $50,000 to $60,000 to $80,000 in legals, really possibly not be able to prove anything. I don't have, call sheets or log sheets or from a year and a half ago on a Saturday. I got a new superintendent. People may have moved on, and so you look at that and you go, yes, I believe this may have happened. I did, I took the free route, right? Make a complaint with CMRAO, but in terms of going to court, the costs didn't seem to match up with the benefits. And so, I had to make the case to say, as an administrator, I'm going to make a business decision to say this makes sense.
And it takes...
I can see a situation where an elected board in that situation, that was partially their money. And they're going, no, I want my pound of flesh. I want someone to pay for this. And that's where it can really be beneficial sometimes, I think. And
it takes the emotion out of it, it's exactly true. I've taken over buildings where the previous company, whatever happened. And, our new board's telling us, well, we want to do a forensic audit. And we look at it and, okay, $15,000 is off. Well, come on, yes, you're probably right. No, it's not in the best interest of the community. As an administrator, I guess it's nice because you can make that, take the emotion out of it, and you're not convincing the board to make that decision that they may not make. They may want their pound of flesh. And so that's a good use of that. Absolutely.
Yeah. So those are a few examples, certainly some, little bit of interesting stories, but the good news is that the stories aren't that crazy. These are communities that get into trouble for one reason or another, and it could be governance-related trouble. It could be financial trouble. It could just be personality clashes. And I do think, as Chris said before, shared facilities committees where there's different views from different bodies, that's an area where I think more and more you may see whether it's on consent where both parties agree, or if somebody makes an application to have an administrator appointed, just to help run things efficiently and take some of the emotion out of it. But condominiums are an emotional thing. And, I do want to also just quickly say, we've talked a lot today about administration and where it happens in bad communities and things like that. As Chris said, this is a small number. There may be a couple of dozen, okay, in the province. Our boards, people that step in and serve on boards are incredibly committed and have the ability and the knowledge to make good decisions. This is the exception. This is, like Chris said earlier, the nuclear option, very
well. For those who listen to the podcast, this whole podcast is the exception. We mostly talk about what's gone wrong, the horrible stories, the crazy 14 building shared facilities, recognizing that, the 98% of things are fine. Maybe not 98. Let's go with 80. But for the most part, things are fine. And for the most part, people can govern themselves properly. With the hiccups that you would expect volunteers to be running multi-million-dollar corporations. They do a pretty good job, 100%.
Yeah.
That's not what this podcast is.
No. And I
You know,
appreciate
yeah,
this is a pretty boring industry if we all sat down over coffee and talked about our well-managed buildings that are run by perfect boards, right? So
exactly.
I appreciate that about the podcast and what we've, all of the episodes we've listened to. And so it is the exception. I definitely acknowledge that. So
Yeah, but 100%. This is a fun exception because this is a bit of an extreme case, and you guys have done a really good job sort of framing it as, responsible people getting together and choosing someone to help them. And I feel like in reality it may not be so clean all the time. Dean had alluded to that and given some stories, but the good thing is you guys are right. There's not that many of these out there. Not that many situations where things have gotten so bad that this has had to happen, and worse has had to happen over and over again. So that's good news. It's good news because if you saw lots of these, we'd have a serious problem. Might have to rethink how this whole thing works, but you're not. So that's good. Yeah, Chris.
I think just if the fact that that remedy is available, that's lurking in the background, helps keep people in check and recognize that, you know what, you don't have this absolute power, or owners can't just do whatever they want. This is there, and I think that serves as a deterrent, and it keeps people, owners, boards, managers, and everyone else acting reasonably, and that's what we need.
Yeah, no, I agree. I agree completely. It's philosophically, it's nice to have democracy and self-management. And we are doing it though in such a way that there is no outside observation. It's not like a municipal or a federal government where you've got media and you've got these things. So to have to have it be completely at the whim of the elected officials, again, the old man who doesn't like the begonias running the $3 million corporation, can be problematic sometimes. And like Dean said, most of the time it's not. Most of the time it's responsible people doing the right thing. But to have this remedy is a nice thing to have. And being difficult to get this is also a nice thing to have, so that it's not used as a bludgeon to go after the people you dislike. So I think it's a great tool, and I thank both of you guys for coming on and explaining it to me, because I don't have a lot of experience with this, and it's always good to know the intricacies of the law and what's possible. So thank you both for coming on. I'll leave it with you guys if you have any other comments or anything like that before we part.
Thanks for having us on. It's great to talk about this topic,
Yeah.
Eric.
That's
All
exactly
right.
exactly what I was going to say. I think the podcast is an excellent outlet, and it was really fun to spend half hour, 45 minutes chatting.
Well, happy to have you guys on, and we'll hopefully talk to you guys soon. Take care.
Soon. Happy holidays.